is there needs to be more participation of the public and the private people, the advocates, the people that have suffered from a human rights violation. We need to create safe spaces for them, and it needs to be publicly funded so that you can tweak the system so that there is a space where concerns can be voiced. And there's so many different examples of how you can bring a very important social, human rights and the change that we're seeking in society is so important that we have to make sure that it has this voice, and that voice, it has resources for that voice. So, I would stress that any of the changes that have to happen have to focus on those changes in which individuals participate more at the earliest possible stages of the process. The system is not that different than what it was when it was thought about even in 1971. It's not that different. The debate between direct access and a commission model or a gatekeeping model, those debates are really I encourage people not to actually go into those debates anymore. I think really the focus should always be on the people that are really suffering from a human rights violation or have been victims of a human rights violation, and try to find solutions that will help them. Like trying to find a middle ground between commission and direct access, which is what Ontario has tried to do. British Columbia, to Vaughn's point, British Columbia almost immediately changed their approach with the direct access tribunal to have almost 90% of their decision making is all procedural or preliminary. So we never get the merits, the substantive merits. We never see a fulsome discussion of what happened to someone. We never get to move to understand the breadth of any systemic discrimination. So those things have to be touched upon now. Those things have been ignored because we were always focused on what do we do with limited resources. So I really think that, while I appreciate efficiency as an administrative law lawyer, we do have to then ultimately see how do we provide a better service to those that are seeking their human rights to be respected and enforced.
I think we need more time to be able to make a fair assessment of the impact of this amendment, and to be able to make informed decisions regarding what we can do. And so I've reviewed some decisions, lately from the Alberta Human Rights Commission. Interestingly, I don't think that decisions of the directors reported anywhere other than being sent to the complainant and the respondent. So the decisions we get to see are the decisions of the chief or the chief's delegate, or decisions from the courts after judicial review. So some of the decisions from the chief that I've seen, there were actually two that came out this month in October. They are still applying the reasonable basis standard, which I found very interesting. So I'll get to those cases. So, however, there was a decision by the interim chief in July, which tried to apply the new standard, the standard of having a reasonable prospect of success. And she actually tried to compare the new standard with what was obtainable prior to the amendment, the reasonable basis standard. She drew on British Columbia jurisprudence and all of that. At the end of the day, she landed where she started. So she said that in substance, nothing has really changed. So she went back to the reasonable basis standard, even though she was applying the reasonable prospect of success standard. So I found that a bit confusing. So we may have to wait for some more decisions from the chief or the chief delegates or the courts to be able to assess the impact. If, as the director said, they are using it sparingly, so why propose the amendment if it's not necessary? Which goes back to what Rob said initially. Why did you take the pain to, do all the work to amend what was already, it was already difficult for complainants? Why raise the bar? After raising the bar, why is it not being applied? Maybe it goes to support the view that it was not necessary in the first place, and perhaps someone thought it might be a useful tool in the director's toolbox to manage their inventory.
We can't forget the other important function of the Human Rights Commission is education and engagement, because and I think it's particularly important in this day and age when we see all of this rhetoric coming out from all kinds of strange places, we don't even have to go south of the border, but we have our own problems with freedom convoys, and the rhetoric that comes out of all of this stuff is really, in some ways, not unlike the rhetoric that we had in the early 1990s with Terry Long and his anti-Semitic speeches and burning crosses and all of that kind of stuff. And we don't need to go there. So I think one of the things that we need to do is we need to put more resources into education and engagement. We have to have better conversations with each other, and we have to have tough conversations, and people need to have access to justice. And because of the nature of human rights complaints, the Human Rights Commission is the only game in town, and there might be better ways to serve both the complainants and the respondents. One model that I've looked at is, and not closely, I don't want to suggest that I've looked at it closely, but workers' compensation. You have an injured worker and you have an employer. Might be a large employer, might be a small employer. But they have workers' advisors and they have employer advisors. Why couldn't we have complainant advisors and respondent advisors? Might do a lot to bring the parties together and get early resolution. It might be something that could be part of the conciliation process. And I understand that it's difficult to keep the sort of intellectual walls between the advisors, but it's something worth looking at, because there's no binding effect of the precedents that come from the Human Rights Tribunal. There's no legal impact except on the parties. You've discriminated against me, Armand, so give me some compensation. And that's the extent of it. So there isn't a great deal of public policy human rights litigation. There's the odd one in the early days, when we were establishing things like reasonable accommodation in Simpson, Sears, and O'Malley, and justifiable exceptions in safety sensitive work like Binder and the CNR and cases like that. But we don't have many really pressing precedents. I mean, obviously what the Supreme Court of Canada says binds all of us, but those decisions are few and far between these days. There could be better models, and if we keep the current model and we don't go to direct access, if we look at better forms of achieving resolution.